All right, next one, judicial branch. So the federal court system actually is not created in the Constitution. The Supreme Court is, but in the end, it's up to the Congress to determine the um, structure of the federal court and also the jurisdiction of the federal court system. Find that in Article 3. So, what is jurisdiction? We've talked about that a few times. So, original jurisdiction is where basically you hear the case for the first time. It's where the case originates, it's where the case starts. Um, the process, it begins either at a district court or you can have original jurisdiction in the Supreme Court. Now, as I'm talking about this is about the federal court system, so don't get that confused with state courts, okay? Then you have appellate jurisdiction. Okay, either your circuit court, or also known as your Court of Appeals, or your Supreme Court are able to review decisions made from lower courts. Okay, but in the end, it's a process that you have to have your original jurisdiction case. Then once that decision is made, you are given the right to appeal. If you appeal from a district court, it automatically goes to the Court of Appeals. It's the decision made in the Court of Appeals or a circuit court that can be challenged beyond that to the Supreme Court. So basically, it's broken down like this. It was created, as far as the judicial structure, it was created in the Judiciary Act of 1789. There are 94 district courts. Okay, they decide civil, criminal cases. Your Court of Appeals or your circuit courts, there's 13 of them. Okay, they are the ones who listen to the appeals from the district courts. This was created by Congress in 1891. Then the Supreme Court, which was created in the Constitution, can choose to hear cases that are from the Court of Appeals or circuit courts. So the president appoints all federal judges. The Senate confirms. There are no formal qualifications to remove them from the political process. They serve a life term. You may impeach a federal judge. So the president makes that appointment to the Supreme Court also. Generally, when making an appointment to the Supreme Court, the president takes into consideration a few things, such as party affiliation, acceptability. Will they pass the confirmation hearings? What type of judicial experience? Perhaps their race, their religion, their philosophy judicially, their political ideology. All those things play a role as far as the appointment process for a president, for a Supreme Court justice. So the Supreme Court, it begins in October on the first Monday, and most sessions will go until June. Although if you look at the calendar for this year's Supreme Court, they're not going to actually hear cases after this month. Okay, so then after that, it's about reviewing cases. It's about coming with final decisions and putting those decisions out, and then also beginning to look at establishing the agenda for the next session. So as far as accepting cases, Supreme Court has really some requirements in order to accept a case. So the first thing is the Rule of Four. The Rule of Four is this idea that only 4 justices have to actually agree to hear the case. It's to try and prevent a majority control over what cases are heard. So in order for the court to basically hear a case, so Supreme Court to hear a case from a lower court, they must issue what's known as a writ of certiorari. This pulls all the records to review from the cases that are below in the lower courts. Once that is determined that they're going to be on the docket, then you're going to have your briefs and oral arguments. The briefs are written and they basically detail the facts of the case and kind of help the justices understand. So once the Supreme Court has this information, they'll begin to look at other things such as amicus curiae briefs, which basically allow for outside groups or outside people who have interest in the case to either support or reject the arguments of the case through briefs that they submit to the Supreme Court themselves. Oral arguments then will take place. Each side will get 30 minutes to present their positions to the justices. It basically is an open forum. Justices have the ability to interrupt and ask questions during that time period. Then they write their opinion, and what happens is you're going to have basically three types of opinions on most cases, especially if it's a split case. You're going to have a majority opinion, which is the opinion of the court, which establishes the precedent. A concurring opinion, which is going to be a justice agrees with the decision, but maybe has a different view on reasoning behind the decision. And then the dissenting opinion. The dissenting opinion basically is written to show why that justices or justice disagreed with the overall decision of the court. They could try and establish some other guidelines for future precedents in their dissenting opinion. Majority opinions, again, are the precedent. So what is judicial activism? We talked about this, judicial activism or judicial restraint. Judicial activism is the idea that the court should play a role in national policies, and they should come in and be extremely involved in the process of laws and lawmaking, and applying the Constitution to social and political questions, and whether or not laws are addressing those issues and those questions. Judicial restraint is the concept that we should avoid going in and initiating, really taking ownership of the legislative process. Instead, strictly just looking at the constitutionality and not the social ramifications or political ramifications of laws or questions that are being brought to the point of to the courts. All right, that's it for judicial